All right, today we're really going to get into the weeds of Patterson versus New York. And look, this isn't just about memorizing some old case. It's about getting inside the Supreme Court's head and mastering their analytical method. We're going to skip the basic lecture stuff and jump right into how these big abstract rules of criminal law actually get applied to a real-life tragedy. So this single question, this is the entire case, right here. Who has to prove what when a defendant says they just snapped? The answer to that question is everything. It determines whether Gordon Patterson is guilty of murder or the much lesser crime of manslaughter. Let's break it down.
Okay, so before we can even touch the legal battle, we have to get a handle on the tragic events that set this whole thing in motion. Now, Gordon Patterson never denied killing John Northrop, not for a second. His entire defense was built around his state of mind. He argued that seeing his estranged wife with another man just sent him into this uncontrollable rage. A rage so intense, he said, that it should knock his crime down from murder to manslaughter. And that one claim, that's the pivot point for this entire legal fight.
So this brings us to the really precise constitutional question that clawed its way all the way up to the Supreme Court. Was New York's law fundamentally unfair? Patterson's argument was, pretty straightforward. He said the Constitution's due process clause should force the prosecution to prove he wasn't acting under an extreme emotional disturbance. But the New York law did the exact opposite. It put the burden squarely on him to prove that he was, and he had to prove it by a preponderance of the evidence.
To sort this out, the court had to go right back to basics. And it all starts with the black-letter law, how New York actually chose to define the crime of second-degree murder in its statute books.
And just look at how simple this is. To convict Patterson of murder, the prosecution only had to prove two things beyond a reasonable doubt. One, that he intended to kill Northrop, and two, that he actually did kill Northrop. That's it. Now pay close attention to what's missing here. There is zero mention of the defendant's emotional state. Unlike the old-school definitions of murder, New York's modern law doesn't make prosecutors prove malice aforethought, which is just an old legal term for a cold-blooded, premeditated state of mind.
Now, New York law did give Patterson a potential out. He could try to argue that he acted under extreme emotional disturbance. But here is the absolute key. It was defined as an affirmative defense. And that legal term is so important because it means it's a totally separate issue. It's something the defendant raises to try and lessen the crime, not an element the prosecution has to worry about at all. And this right here, this is the constitutional bedrock. It was established in a huge prior case called In re Winship. The prosecution must prove every single piece of the crime exactly as it's defined by the legislature. This rule frames the whole debate. Is Patterson's emotional state an element of the crime itself, or is it something else entirely?
Okay, now we get to the court's analysis. This is the crucial part where they connect all the dots, the facts, the rules, to reach their decision. The reasoning here is absolutely everything. This chart just lays out the court's core logic perfectly. They drew a really, really sharp line in the sand. The state had its job, prove intent and the act of killing. The defendant, well, he had his job, prove his emotional state if he wanted a lesser charge. And because Patterson's defense didn't actually cancel out the fact that he intended to kill Northrop or that he succeeded, the court just saw it as a completely separate issue that he had to prove himself.
The majority basically reasoned that New York was being, pretty generous by even offering this defense in the first place. The state could have just defined murder as an intentional killing and just left it at that, period. So by creating this defense but making the defendant prove it, New York was just striking the balance. And honestly, from a practical view, the court thought it would be a total nightmare to force prosecutors to disprove every single potential defense a defendant could possibly dream up. So the court had to deal with a recent case of its own called Mullaney, but they found a way to distinguish it to say this case was different. See, in Mullaney, the law in Maine was written differently. It explicitly included malice aforethought, which really means the absence of a heat of passion provocation, as part of the actual definition of murder. So in Maine, proving the defendant's calm emotional state was an element of the crime the prosecution had to prove. In New York, it just wasn't. But this neat little distinction did not sit well with everyone on the court. Justice Powell led a really powerful dissent, and he warned that the majority's logic was, a dangerous and way too formalistic approach to the Constitution.
Whoa, Powell's argument was just scathing.
He was essentially accusing the majority of rewarding clever wordsmithing by legislatures. He argued that they were basically handing states a roadmap to get around fundamental constitutional protections just by changing how they write their criminal statutes. So the dissenters proposed a much deeper, more substantive test. They said instead of just reading the statute, courts should ask two big questions. First, does this factor make a huge difference in the punishment and public shame that comes with a crime? And second, is it something the law has cared about for a long, long time? For the dissenters, the difference between a calculated murder and a killing in a fit of rage was just fundamental to our sense of justice, and they felt a majority was letting legislatures erase that tradition with the stroke of a pen.
So you've got the majority's formalism on one side, the dissent's historical test on the other. Where did the court finally land? The majority's view won the day. Patterson's conviction was upheld. The court ruled that as long as the state proves all the official listed elements of a crime, it can, constitutionally, put the burden of proving a mitigating, affirmative defense on the person accused of that crime. All right, let's boil this whole thing down. What's the single most important principle this case adds to our understanding of constitutional criminal procedure? So the crucial point is this bright-line distinction. The Constitution protects you by making the state prove every single element of the crime, as it's written in the statute book. It does not require the state to also disprove every possible reason you might offer for why you deserve a lesser punishment. And that brings us right back to that powerful, lingering question that Justice Powell's dissent raised. This case drew a very clear line, but it also exposed a potential loophole in our legal system. It leaves us wondering about the true limits of legislative power and whether procedural fairness can really be protected by grammar alone, a tough question that courts are still grappling with today.